And why are you not living with your parents?
He is now, Your Honor. He was not.
Okay, why were you not living with your parents before?
They didn't want me at home
Why not?
because of my inconvenience, because of my attitude,
All right, what was the issue with your attitude?
anger, disrupting the environment at home.
He walked in expecting the court to review 2 plea agreements. But Judge Boyd wanted more than paperwork. Why was he not living with his parents? What was the issue with his attitude? Why was work, school, and structure still unresolved? The answer starts small, but the hearing quickly turns into something bigger. In Judge Boyd's courtroom, one explanation can open the door to everything else.
All right, court is calling 2024 CR 012811 and 2025 CR 001217W, State versus Dalen James Newman. Can I have parties announced for the record? State.
Megan Gallery for the state.
Marshall D. White and Mr. Dylan Newman, Your Honor.
And are you Mr. Newman?
Yes, ma'am.
Counsel, have you received all discovery in this case and did you review with your client?
I am satisfied at this time, Your Honor.
All right, the court will find that the state is in compliance with discovery. And there's an application in each case, counsel?
That's correct, Judge.
All right, each of the cause numbers, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And the cause number ending in 1217W, did you review the document entitled Waiver of Indictment, Reading of Information and Rights on Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes.
Did you understand by signing that you're waiving your right to have the grand jury hear the evidence in this case and make a decision on whether or not to indict this case? Did you understand?
Yes.
And did you also understand you're giving up certain rights your attorney has? Namely, your attorney has the right to have the passage of 2 days from the presentation of the information and 10 days to prepare for trial. Did you understand? And do you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information in that cause number?
Yes, Your Honor.
And did you review the indictment in the other cause number?
Yes, Your Honor.
Counsel, in each of the cause numbers, do you waive the reading of the information in the indictment?
Yes, Your Honor.
State, in each of the cause numbers, are you proceeding as presented on the information as presented in the indictment?
Judge, on the case, the waiver case with the information, on what offense that's on.
It appears that you're proceeding on the Class A.
Yes, that's correct, Judge.
Any objection?
No, Your Honor.
On that other indictment, we're proceeding as charged.
No, thank you. All right. Did you understand in the cause number ending in 7W, the state is proceeding on the lesser included offense of assault causing bodily injury family? That is a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Do you understand? And the other cause number, you are charged with the offense of theft of a firearm as a state jail felony. Range of punishment is up to 2 years in the state jail facility and as low as 180 days and up to a $10,000 fine. Do you understand?
Yes, Your Honor.
In each of the cause numbers, if you have a plea bargaining agreement, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering into these plea bargaining agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargaining agreements in each cause number?
Yes, Your Honor.
You gotta speak up, Mr. Newman. I barely can hear you. I'm standing right next to you. He's gotta hear you.
Thank you. And the cause number ending in W, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine. And the other cause number ending in one, and the number one, if the court were to grant your application for deferred adjudication, your deferred adjudication will revoke. The court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand?
Yes, Your Honor.
Counsel, each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In both instances, I do, Your Honor.
Mr. Newman, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
All right. And the cause number ending in W, the state is proceeding on misdemeanor family violence assault. They're recommending deferred adjudication. This is run concurrent with the death of a firearm. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition,
Yes, Your Honor.
and you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
And the other cause number, according to the plea, there's a $0 fine. The case will run concurrent with 2024 PF 18961. I'm assuming that's the W case.
It is, and I just wrote that in the indictment.
All right, so these two cases will run concurrently. Do you understand?
Yes, Your Honor.
And there is to be restitution of $629.99 to Academy. And the state is recommending deferred adjudication. Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
And did you review this plea bargain agreement with your attorney?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No such motions, Your Honor.
Outside the agreement and the W cause number, the state is asking that your community supervision be for a term of 1 year. There be no contact with the complainant, a BIPP, TAIP evaluation and follow recommendation. And the cause number ending in the number 1, they're asking that you defer adjudication be for a term of 3 years. There be a TAP evaluation, community service hours, and no contact with academy stores. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations.
Yes, Your Honor.
And the cause number ending in W to the Class A misdemeanor, how do you plead guilty, not guilty, or no contest? And in the cause number ending in the number 1, how do you plead guilty, not guilty, or no contest?
Contest.
State any evidence in each of the cause numbers.
In each cause, the state offers states to exhibit and provide attachments.
No objections, Your Honor.
All right, and state you may be, I'm sorry, state in the cause number ending in W, would you speak with the complainant?
Just give me a minute. Yes, Your Honor.
State you may be excused. And each cause number, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, the state will call, and the right to remain silent? Do you understand?
Yes, Your Honor.
Did you understand that in each of these cause numbers today, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication in each cause number. Counsel, are we proceeding with sentencing?
Yes, Judge, and if I may say a few words on Mr. Newman's behalf, respectfully, we ask the court to follow the plea bargain above the line. With respect to the items recommended by the state below the line, Judge, we recommend that the court place a condition where Mr. Newman has no harmful injurious contact with the alleged victim. I believe that is her wishes, the victim, that is to say, and they are expecting the child together in the very coming months, near months. In addition, Mr. Newman is, he was at the time, Judge, been battling some homelessness. He's informed me that he has been allowed to come back into his home with his parents. And he's, currently trying to work through getting employment. He's a young man, like I indicated, just turned 20 years old this past August, I believe.
So
And that's what I have to say on behalf of Mr. Newman.
All right. And why are you not living with your parents?
He is now, Your Honor. He was not.
Okay, why were you not living with your parents before?
they didn't want me at home
Why not?
because of my inconvenience of my attitude.
All right, what was the issue with your attitude?
Anger, disrupting the environment at home.
Why were you doing that?
I felt stuck. I was trapped. Couldn't do anything and get out.
What were you trying to get out of?
I was trying to find work, trying to get up on my feet, and I just couldn't.
Well, how far did you go in school?
I got to my freshman, sophomore year, and I got homeschooled
Sophomore year, freshman year of what? High school?
high school.
All right, so,
And then
and you say you were homeschooled, so why didn't you complete high school?
I graduated,
All right, so you graduated from high school.
but I did it through homeschool.
All right, so you graduated from high school through homeschool.
Yes.
So did you start going to school and then were homeschooled?
Yes.
Why?
They felt that I was being too bad.
Was they?
My parents.
All right, so they took you out of school to be homeschooled.
Yes.
So you have your, I guess, your high school degree. And you can't get employment. Why couldn't you get employment?
People just weren't hiring at the time.
Where did you look for employment?
All over,
No, where is that?
like fast food industries, construction. I looked in retail.
So you didn't think maybe you needed to increase your level of education or go to a trade school?
I thought about that as well, but
But
I
did you
haven't
do it?
further proceeded. No.
All right. And then the person, the complainant in this case, in the police report, what I read is that she told you she was pregnant. And then both of you were drinking downtown. What were you drinking downtown? Alcohol?
Drinking downtown.
No, this is what it says in the stipulations. It says, victim stated that she was in a dating relationship that was on and off with the suspect, that's you. And they were trying to work things out because victim is pregnant and she made you aware of the pregnancy. Victim stated that she and S1 had been driving and drinking all day and she wanted to go home. It says that victim is homeless, but wanted you to have a place to stay. So, and she tried to, well, she wanted you to have a hotel room. And she tried to drop you off, but you didn't want to be dropped off. What's that about?
That
The fact that she tried to buy a hotel, well,
yeah,
sorry, she tried to get a hotel room for you and to drop you off, but you didn't want to stay.
No, it wasn't that I didn't want to stay. We were there at the vicinity when everything happened, and from being downtown, we never drunk.
All right, so
Or
then,
was downtown.
okay, so then the hotel that she obtained for you, why do you want to stay there if you were homeless?
I was trying to stay there.
Then I don't understand, how did this go from you being homeless, she's trying to get you a place to stay, and then you're hitting her?
She didn't want to get it for me because of someone else that was with me. And I told her that that person wasn't going to be there. It was just a ride. I was just a ride.
Was it a girl?
And then she proceeded to strike me while I was driving. So I stopped the car and I didn't retaliate in hitting at first. I just poured her drink out. It was just Sunny D.
And whose car were you driving?
I was driving hers.
All right. In cause number 2025 CR 001217W, The court is going to sentence you to 1 year's deferred adjudication. There's to be no contact with Shayla Mills. Y'all are going to have to do child custody through a third person. And counsel, if she wants to have contact with him, she'll need to come in and speak to the court.
Oh, I understand, Judge.
There's to be 80 hours of community service restitution. I'm going to order parenting classes. Once you, I'm sorry, not 80 hours. I'm going to order 100 hours of community service restitution. I'm going to order parenting classes. Once you've completed parenting classes, 50 hours of the community service will be deemed satisfied. And then the remaining 50 hours will be satisfied if you obtain any type of trade school certification or you complete a higher level education. Otherwise, you can just do the 50 hours of community service and they're going to have you picking up trash somewhere. You understand?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider with minors. There's an affirmative finding of family violence. This will run concurrent with 2024 CR 02811. There's to be the BIPP course and field visits 1 time per month for 6 months. And cause number 2024 CR 012811, the court will sentence you to 3 years deferred adjudication. This will run concurrent with 2025 CR 001217W. And counsel, I'm also going to put in the 2024 PF 18961 case in case there's some confusion in the system.
Judge, I would just say, with respect to the bib class, do you want him to take a bib course in addition to try to get a job and get some training?
Yes,
I think that's going to be, he's not going to be able to do it.
I'm sure he will. And there's going to be 3 years deferred adjudication. The cases will run concurrent. There's to be restitution and no contact with Academy. And the restitution amount is $629.99. Again, there's regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months. There'll be 100 hours of community service restitution. And the same, if he completes parenting, 50 hours will be deemed satisfied. And the other 50 hours will be deemed satisfied if he obtains a higher level education or completes some sort of trade school. And let me see. Probation, is there anything else with regards to that case?
No.
Is there anything else you need from the court in either of these cause numbers?
No, Your Honor, but I don't know if Job Corps has anything to help with my cases.
Oh, the probation will speak to you. And each of the cause numbers, did you review the documents in its title trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And each cause numbers, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And the cause number in 2025 CR 001217W. Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record to be successful on probation in this court. Communication is key. If there's an issue, let probation know. If you feel as they're not addressing it, you can always come back to the court. All right, good luck to you. Thank you for addressing appropriately for court. We're on the record in 2024 CR 011824 State versus Richard Madrigal Flores. Could I have parties announced for the record? State.
Virginia for the state of Texas.
Attorney Alvarez Philip for Mr. Madrigal Flores.
Are you Mr. Madrigal Flores?
Yes, ma'am.
All right, this defense is asking for a reinstatement of the PR bond. The defendant is charged with aggravated assault with a deadly weapon. So the court's first question is, why was the PR bond revoked?
My understanding, Judge, just according to the update letter that was provided from pretrial services, is at the time that he was on bond, that there was a GPS issue that they didn't have communication with it. So the next step, according to the letter, was that they reached out to the number for him, which was his mother's number. And she wasn't picking up and giving him the message that they were trying to get a hold of him. So as a result, there was an emergency warrant issued by the magistrate, it looks like sometime at the nighttime. And then he was subsequently arrested a few days following that. So he was out for about a week.
All right, so was he arrested with the GPS on?
Yes, ma'am. It was over the weekend.
No, I mean, this is what I want to know, like, did he still have a GPS on his ankle?
That information I don't have, Your Honor. However, we would like to clarify at least. I understand what defense counsel is saying about the communication signal being lost and his mom's phone number. However, at least from the violation report that the state has, and I believe is in front of the court, it looks like maybe the reason that the GPS signal was lost is because the defendant wasn't charging his device. Additionally, it also seems like when pretrial services call the defendant, he rejects or hangs up the calls. And so that's the information in front of the state. I just want to put that on the record.
Okay,
If I could just follow up with a few questions for him.
sure. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Richard Madrigal Flores.
Mr. Flores, when you were released on November, or when were you released, excuse me?
I believe I was released November 22nd.
And that was with the GPS?
Yes,
And where were you residing?
at my mother's house.
And the phone number that was provided to pretrial services, was that your mom's phone number?
That was my mother's phone.
And how old is your mother?
74.
And can you explain to the court, does she work night shifts?
Yes, sir. She works night shifts at Toyota 74. She sleeps from about 7 o'clock in the morning all the way till about 3:30, almost 4. Gets up and will get fought.
And during this period, did she ever notify you that pretrial services are trying to get a hold of you?
No, she was still asleep.
You understand when you're out on bond on a GPS and you provide a number, they have to have a reason, a way to get a hold of you, right?
Yes, sir.
Do you have a current number today?
We just ordered a phone. All we gotta do is pick it up.
Okay.
I don't know the number as of right now. But when I get back this afternoon, I'll be able to call home to
So,
get the number.
so if you're given an opportunity to get out on a PR bond again, you'll have your own phone number. You're not relying on your mother, correct?
That's correct.
Okay. And then, do you remember when you were picked up? Arrested?
Picked up November 25th,
Okay.
Monday. Reported at 9 o'clock in the morning by phone, like it was asked me. And then by 11:30, they asked me to check in by 1 o'clock. I live in Poti. It's an hour drive. So I got dressed real quick, jumped in my car and drove straight down here. I made it by 1 o'clock.
And this is at pretrial services?
Yes, sir.
And when you got there, they arrested you?
Yes, sir.
And you had the GPS on at that time?
I did.
Okay. So are you asking the court to grant you the PR bond?
If possible, please.
And just one other thing, do you have employment available to you?
As of right now, I'm in the process of gaining employment. I'm trying to go work with my mom at Toyota. I also tattoo on the side.
I pass the witness, Your Honor.
All right, any questions?
Just a few brief questions. Mr. Madrigal, Mr. Madrigal, I'm sorry. When you were initially given the PR bond, were the terms of how the UPS was discussed with you?
Yes.
Do you fully understand that?
Yes.
And did you agree to regularly keep up with it while you were out on bond?
Yes.
Okay. Now, did pretrial services also discuss how to keep in touch with you?
They gave me a phone number and they told me to report by Monday morning. That's what I did.
And did you regularly report when you were out?
I reported that one time early in the morning at 9 o'clock and they asked me to report by 1 o'clock in person. And I did.
Do you feel it is your responsibility or your mother's responsibility to check in?
It's my responsibility.
No further questions, Your Honor.
All right, any further questions?
You followed the instructions of pretrial services, correct?
Yes, sir.
And you weren't aware that they were trying to get a hold of you because you didn't know that your GPS wasn't communicating with the tower, correct?
Correct.
Okay. And had you known about it, you would have got that fixed, correct?
Yes, sir.
Okay. Pass witness.
All right, any further questions? I have a couple of questions. All right. When's the last time you charged your GPS?
I believe I plugged it in about 7 o'clock Sunday morning, Monday morning.
All right. And how long does that charge last?
I looked up the GPS online, and to get a better understanding on that part, and it says that the charge lasts up to 35 hours.
And the other question, what is 1986 to you?
It's the year I was born.
Right. And the Cadillac tattoo?
I was the type of vehicle my brother died in.
Ah, and what is that? The White House or something on the other side? Okay, and what is that on the other side?
It's the LA. There's Los Angelitos.
Mhm. And what is your ties there?
It was a gang that I was representing when I was a kid.
Okay. All right, is there anything else?
Another vote, Judge.
Anything further? All right, motion for the PR bond will be denied. Is there anything else?
No, nothing further.
All right, we'll see you back on March 6th, okay?
Yes, ma'am.
All right, thank you so much. Court is calling 2024 CR 011812, State versus Walter James Johnson. Can I have parties announced for the record for the state? Defense.
Hector Groza Jr. for the defense.
And are you Mr. Johnson?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have him.
Mr. Johnson, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Sure.
Counsel, do you waive the reading of the indictment?
We do well.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, Mr. Johnson, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Sure.
You understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Sure.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Sure.
Did you understand, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Sure.
Did you understand by entering this plea, you were giving up those rights?
Sure.
And did you intend to give up those rights and enter into a plea in this case?
Sure.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea?
Oh, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed to 156 days in the Bexar County Jail under 1244. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There's no such motion.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers states exhibit number 1 and attachments.
All right,
No.
you may be excused. Any objection?
No objections to the defense.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing the state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are.
All right, anything you wish to say on behalf of your client?
Nothing.
All right, the court will follow your agreement. The court will sentence you to 156 days in the Bear County Jail under 1244. There's a $2,000 fine, and time and money are to run concurrent. Is this a judgment satisfied?
It is, Your Honor.
All right, and the court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Sir, how old are you?
65.
All right, no good can come of this using, no good is living on the street. I understand that people are homeless, but there are plenty of places that you can live at. And when you're homeless, you know, it's sad to say, but you can't be choosy, right? Some people say, I don't want to stay at the Haven for Hope, or I don't want to stay here, but that's all that's available, right? And if you have a drug problem, which it appears you have, you don't want to be that person that I end up, or somebody says, hey, Judge Boyd, did you see this in the news? And it's you in the news and somebody's identified your body. There are so many free places they have in San Antonio now where you can go live and have your drug issues addressed. But you've got to reach out to want that. If you don't, nobody can help. Okay? All right, good luck to you. You're welcome. Have a good day.
These hearings show how Judge Boyd looks beyond the surface of a courtroom explanation. In the first case, the issue was not only the plea, it was maturity, housing, work, education, and whether structure could actually hold. In the second case, the question was whether release conditions were being treated seriously enough. A GPS issue became a trust issue. And in the final case, the warning was simple: help exists, but the defendant has to reach for it. That is the pattern in Judge Boyd's courtroom. She listens to the explanation, but she measures it against responsibility, supervision, and the record in front of her. Comment which ruling carried the most weight, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.